All right, it's 2:30. Good afternoon, everyone. This is the Office of Consumer Credit Commissioner stakeholder meeting to discuss the Attorney General's opinion interpreting Chapter 393 of the Texas Finance Code with respect to credit services organizations. My name is Michael Rigby. I'm the General Counsel for the agency, and I'm joined here by our Commissioner, Leslie Pettyjohn, Deputy General Counsel, Matt Nance, and Paralegal Ginger Harmon. I'd like to turn things over to the Commissioner for a few opening remarks.
Thank you, Michael. First of all, I want to thank everyone for their attendance today, whether you're here in person with us, thank you, or whether you're also maybe attending online the webinar. We are grateful for your presence and participation. We are here, as Michael said, to gather information about the recent Attorney General opinion, KP-00277, that was issued on November the 1st. In particular, we're here seeking information about the relevance of this opinion to our regulated businesses, to consumers, and just to the overall regulatory landscape. In our process, when we have stakeholder meetings and we develop new regulatory policy or we develop rules or bulletins, we work really hard to maintain an open and transparent process when we go through that development. And that process only works when we have the committed participation of interested stakeholders. We need stakeholders to step up, speak up, and share their views. It is really difficult for us to create regulatory policy in a vacuum. We can do it, but the results always are not what we would like them to be. It's only by full participation in this open and transparent way that we can develop the best policy. Best policy needs to inform both the stakeholders and consumers where the boundaries are and ensure that parties are fully aware of the applicability of laws as well as the potential devices and subterfuges that may result in evasion. So the best policy that may come out of this may be a proposed rule to the Finance Commission. We'll consider that. It might be an advisory bulletin. Regardless of whatever it is, it's imperative that we have participation and input. This process doesn't work if some parties sit back and don't provide feedback during the development. So you're encouraged today in the strongest possible terms to tell us what you think, to speak up. In the notice of stakeholders meeting, we've provided about 10 questions to help guide our discussion and guide our formulation in this conversation. Again, I want to thank you very much for being here and participating. And at this point, I will turn it back over to Michael Rigby.
Thank you. Like the Commissioner said, I want to thank everybody for coming to this meeting and participating in this process. These meetings help us produce the best possible approach to ensure a fair, lawful, and healthy credit environment to ensure that economic prosperity grows for all Texans. We are holding this meeting here in the Finance Commission building. There are materials over here if you need a copy of the opinion. There's a sign-in sheet and also a copy of the notice of this stakeholders meeting. We're also holding this meeting online through GoToWebinar. Some of you may be listening on your phones, some may be watching or listening on your computers, and some may be doing both. For those of you on your computers, there's a window where you can submit questions. If you have a technical question about using the webinar, you can type them in, and Ginger will try to answer those for you. If you're listening online and have comments on the notice itself or on the discussion here in the room, go ahead and type those questions in at any time, and we'll get to those as well. And if you're on a computer with a mic, there's a function where you can raise your hand and participate and comment verbally. If you're here in person, I would appreciate it if you come up to the table and speak into the mic. That helps everybody both here in the room and online hear you. It is possible if you speak from your chair. We can do it that way also, but I'll need to repeat the question so that the folks online can hear the question. Okay, so let's start with our slide. Okay. There we go. All right. So I just want to provide kind of a general overview of regulatory background and the Attorney General's opinion. The opinion deals with CSOs and CABs that are subject to Chapter 393 of the Finance Code. A CSO is a credit services organization that improves the consumer's credit rating or assists a consumer in obtaining an extension of credit. And a CAB is a CSO that assists a consumer in obtaining a payday or title loan. The AG opinion concludes that the CSOs are not restricted to solely obtaining a payday or title loan, but may extend credit through other means. The opinion or the request was to the Attorney General was asked whether the CSOs could also do signature loans, but the opinion did not address that. It declined to address that particular issue. A CAB transaction, we've got some labels here that may help facilitate the discussion. For purposes of the discussion, we're defining a CAB transaction as a transaction where a CSO acting as a CAB obtains a payday or title loan for a consumer, and a non-CAB transaction is where a CSO obtains a type of loan other than a payday or title loan. Again, these are not statutorily defined. They're just for purposes of discussion to help us understand the issues. Okay, so the first question we've presented for purposes of discussion is, does the opinion's analysis affect the regulatory landscape for CAB transactions, that is, deferred presentment transactions and motor vehicle title loans? Would anybody like to start?
We have 29 attendees.
So we have 29 attendees online. Do we have any questions or comments from any of those folks?
No questions or comments yet.
All right.
You're looking for someone to say something, I would say yes.
Yes, we have a yes. Do you have any further comments on how the opinion might affect the regulatory landscape for CAB transactions?
I would say that on some of the conversations that I've understood that are ongoing, that I would like to know from others, perhaps, what's at the root of it, maybe who asked for the opinion to begin with, and maybe help understand where they're trying to make things go.
Okay. So for those folks online who may not have heard the comment, the participant said that, yes, there is an impact. He's curious as to where the request for the opinion came from and what the interest of that those stakeholders might be. Does anybody have a response or insight into where the request came from or what the where the request was going or heading? I don't hear anybody. Okay. Does anybody have any other insight, opinion, suggestion, or questions about the opinion's effect on the regulatory landscape for CAB transactions? Can you come up to the mic, please? Thank you.
My name is Ann Bedore with Texas Appleseed, and I agree with the other commenter that yes, it creates substantial questions. It creates a lot of concerns from a consumer protection perspective because it essentially throws chaos into a system that was previously contained, and it's hard to predict what that chaos will reap. But in the past, when we've seen this kind of chaos in the market, like we saw pre-2011 in the law changes, it only created harmful products and harmful dynamics, and so I think it does create a lot of questions and opens up the possibility for substantial consumer harm.
Okay.
Sorry, Ann, just had one follow-up question. Do you see those effects being limited to the non-CAB transactions, or do you think it also affects the CAB transactions as well?
I think that the line between the two is going to be perhaps so hard to discern under this that I think my sense of
have a sense of how we as a regulatory body might mitigate that risk or mitigate the consequences of the chaos as you describe it?
It seems that the tool that the AG opinion has left to the agency is very detailed, fact-intensive assessments of subterfuge and compliance with other aspects of the law. You know, I mean, I think that I don't know that the agency has the capacity to offer an alternative interpretation. This interpretation, like they deem, is not a statement of law, but a statement of opinion that is, you know, is there perhaps an alternative interpretation that can make the statute make more sense and create a better pathway forward for the agency? Because right now I think that it establishes so much gray area that it, like I said, it will have tremendous potential for creating consumer harm.
Thank you. Are there divergent opinions? Does anybody think that the opinion creates clarity instead of chaos or has some other effect? Again, we'd really like to hear what your opinions are so that we can understand the impact of the AG opinion itself.
Craig Bennett. I'm sure you know this, Michael. I've taught Texas administrative law at UT Law School for the last 12 years. To me, the AG's opinion hasn't changed anything. I have looked at this issue during the legislative session, and even before the AG's opinion was issued, had come to the exact same conclusion that the AG had come to, that there is this dichotomy created of CAB entities and non-CAB CFOs. To the extent that there needs to be clarification, I'm sure the legislature can step in. To me, it didn't change anything. It was an opinion that I thought was entirely where I had come out when I looked at the issue during the legislative session in relation to various statutes that had been proposed. So I guess, if anything, to me, it clarifies what I already believed the law to be. So I don't know, and from my position, it wouldn't require any action, at least not to the extent that there was. I think it would be tricky for the OCCC to get into that, to stay consistent with whatever the statutory mandate is. Certainly you have broad authority to adopt rules in general, but I think it's kind of tricky to speak to an area that the legislature may not have given clear direction on. So I don't think it's changed anything, to be honest. Yeah. You asked for whether there's a divergent opinion.
Yeah.
I see that.
Yeah, we appreciate that. I think from our perspective as regulators, it is a difference in our regulatory approach. For many, many years since we first acquired authority over this, we've taken the position that that those kinds of extensions of credit are limited to deferred presentment transactions and motor vehicle title loans. So we're having to kind of shift our perspective to accommodate this opinion and to incorporate it into our approach. You're hearing from the consumer groups that this creates some chaos in the marketplace. Do you have any suggestions about how that chaos, disruption, confusion, however you want to describe it, might be mitigated or addressed, given that, at least from the regulator's perspective and probably from the consumer's perspective, there was a different opinion than the one you expressed?
Well, I think there's one thing that you're starting from a good spot, and that is you don't have rules that run afoul of any particular law. You were taking an approach based on your own interpretation, but you didn't have rules that you put in place that you now have to deal with some potential conflicts between rules and AG opinion and statute. So I think you're starting from a good spot, because really all you're talking about is perhaps changing your internal approach to how you look at these and how you approach these different sorts of transactions, and not necessarily having to go back and look at revising rules or anything. So I think to that extent, it gives you the flexibility to deal internally with this in a way that would be a little bit trickier if you had rules on the book that maybe you had to modify, within whatever. So I think it really comes down to you guys just kind of developing internal policies for how you approach it, and look at this. Certainly, I'm not aware, but in terms of, it may be different, but I'm not aware that it creates chaos necessarily in the marketplace. I think we've only had this opinion for a little bit time we'd be able to tell. And in fact, I think, honestly, without sufficient time to see how this plays out, how things play out over time, I think it's difficult to know the impact. And you run the risk of acting too quickly and taking actions that may not be consistent with how things work out. So I think, from just a general, speaking as a professor and a regulatory person who has looked at administrative law, I think it's good to just gather information, and I don't think you're in a position you have to move quickly because you don't have anything you have to rescind or revoke.
Okay. Thank you. Does anybody else have another perspective or a question about this particular area? All right. If not, we have a question from online. The question is, what would the non-CAB CSO, online lenders who don't purport to be, I guess, doing payday loans? And this is from Melinda Ramos. I'm not sure who she represents. But like I said at the beginning, the non-CAB CSO business entities or non-CAB CSO transactions, as we've defined for purposes of discussion, are credit services organizations that are not doing deferred presentment transactions, also known as payday loans, and not doing motor vehicle title loans. Those two transactions are defined by statute in Chapter 393, and the non-CAB CSO transactions would fall outside of those definitions as found in Chapter 393. I hope that helps the questioner get some clarity around that. If not, she can provide additional follow-up questions. Does anybody else in the room or online have additional perspectives or insight or questions or comments about this first question?
Good afternoon, everyone. My name is Mark Jetchev. I represent the City of Austin Telecommunications and Regulatory Affairs Office. Excuse me. And we're the regulatory department that deals directly with credit access businesses. So part of what I would like to ask and comment on the last couple of speakers is about the chaos that's being added through this opinion. Unfortunately, even right now, with some of the legal cases that we have at municipal court, and with the responses, pardon me, should have got some water before I started speaking. With some of the responses from to our audits, some of the CABs have essentially said that the products that they're offering don't really match what a payday loan or an auto title loan actually is. And that's the argument that we're hearing in municipal courts as well. It said that this particular case should be dismissed because it doesn't, we don't need to comply with this because we're not acting as a credit access business. So now you have the AG that essentially lends quite a bit of credibility to such a claim by saying, yes, in fact, if you are acting as a CSO instead of a CAB, you can pretty much claim any kind of a product. So our question is, what does that mean? What does that look like to you guys? What outside of a payday loan or a auto title loan, how does the OCCC see any of these other products that now are possibly just given out under the guise of a credit services organization? So, excuse me, that's part of the question that I have, like I said, towards you guys. And that's something that we're also thinking about in the background of how the City of Austin is going to try to fit into a new regulatory landscape. Considering, such as, of course, as the gentleman said earlier, the AG didn't write any new laws, right? There's nothing new on the books. The same, so in a way, it doesn't necessarily change the regulatory landscape because it doesn't change the laws that we have. But when a judge is listening to an opinion from a CAB representative that are saying, well, CSO loan. Now we have an opinion that actually backs that up. So it does, in fact, throw a wrench into the works of something that beforehand was at least somewhat streamlined. So is there, at any point in time during this meeting, I'm just curious, are we going to hear from your opinions on the AG opinion, the OCCC?
Well, we've got the basic background, but it comes from the years that we've been taking a particular approach. We're here today to gather the input of our stakeholders and to understand what the comments and concerns are with respect to the AG opinion and how that might change things. And so, we're really in kind of an information gathering mode right now. At some point, we will, like the commissioner said, probably take some action. That could be a bulletin, it could be a rule action, and that's what we can do as a regulatory agency. I think perhaps, I think it was Mr. Bennett or may have commented on the potential for legislative action, or the opinion itself commented on, whether there was or was not legislative action to date and the potential for future legislative action. So, that's not up to us. We don't pass laws. We just interpret them and enforce them. So.
Okay. Even that is in a way, we would be also curious to see the OCCC's position as it comes out of this, because we just want to step on anybody's toes, and our responses follow yours. That being said, I once again want to reiterate that yes, the laws haven't changed, so the way is just business as usual. But also right now, just somebody saying, yes, you can do anything. And I'm not as familiar with state law as I am with city ordinances, but it doesn't seem to be anywhere in the finance code that defines what those products could be limited to. So again, going back to that chaos, it could literally be anything. And so far, through the audits that we've done and any of the cases we have in municipal court, we don't necessarily find out that a product we don't find out the CAB's opinion that the product doesn't necessarily match the regulations until after we have said, well, we think that this is not compliant, and which is after the fact with their response saying, well, actually it isn't because it's not a CAB law. We don't get that information beforehand. So if we don't get the information what the products are going to look like ahead of time, and we won't find out what their opinion of their own products is until after we have cited a alleged violation. Well then, and we have we have nothing in the statute to actually limit what kind of product it is. I mean, if that doesn't define a chaotic regulatory landscape, I'm not sure what does. Great. Thank you very much for your time.
Thank you. Appreciate it. We have another online question, which is from Rachana Chen, who asks if the OCCC issues a bulletin, what is the effect of that, given that the AG opinion explicitly states that courts have no obligation to defer to it, and the legislature has not pronounced on the issue? She appears to be with the faith-based community, the Texas Catholic Organization. Okay, so let me look at that one time. If we issue a bulletin, what's the effect? So this is kind of a quandary that we face as state regulators with respect to bulletins. If you read the opinion itself, the Attorney General noted that courts typically do not give deference to agency bulletins, and so while we do and have in the past issued bulletins to help guide our licensees and registrants to comply with the law, we think that's generally a good idea. It has a minimal effect when it comes to interpreting that in a court and with respect to the AG. So the questioner is correct that there's some limitations to the impact of a bulletin that we may issue. Rule actions, on the other hand, tend to be, they're much more formal in nature. They're prescribed by the government code, and there is some deference that is given by the courts to those rule actions. So, but nevertheless, we want to make sure that we're communicating clearly with our stakeholders, with our licensees, registrants, and to the consumer groups to make sure that everybody's on the same page with respect to our perspective in terms of our regulatory approach. Does anybody have any follow-up question to the original question or any of the comments so far? I'm going to move on to question number 2. Question number 2 is, must persons engaged in non-cab transactions comply with all requirements of Chapter 393 other than those that apply specifically to cabs, that is, Section 393-201C, Subchapter C1, and Subchapter G? Any comments?
By persons, you mean persons acting as a creditors organization?
The question is about persons engaged in non-cab transactions.
From the definition.
Yeah.
CSO is implicit in that.
Yeah, I mean, you could have unlicensed or unregistered CSOs, but yes. Generally, I think we're referring to the registered CSOs, yes. Any insights or comments about how that might look or work, or now's your chance. Online. As Matt says, I should wait 30 seconds before moving on, so I'm going to give a little break in case anybody has a thought.
And just so the web folks can hear you, if you have a question or would like to share your comments, if you could please come up to the mic, because I'm getting some just feedback saying that sometimes the folks that are commenting, we can't hear them as clearly as we would like. So if you could please come up to the microphone when you have a question, that'd be great. Thank you.
Okay. Anybody else before I move on to the next question?
Can I rephrase it maybe as the negative and say, is there anyone who believes that those provisions do not apply? That there are any provisions that do not apply? Okay.
All right. Question number 3 is, are persons engaged in non-cab transactions subject to the enforcement authority of the Attorney General under Section 393-502? Or we can phrase it in the negative as, is there anybody who believes that the Attorney General doesn't have authority over Chapter 393 under that provision?
Crickets.
Crickets. Anything online?
Nothing online.
Okay. Last chance.
I assume that means that they are under the enforcement authority.
Yeah. I don't see anybody contesting that proposition. All right. Number 4, are persons engaged in non-cab transactions subject to local ordinances and the enforcement authority of local government? Rob, you're moving in your chair. Did you have a comment, or should I rephrase it in the negative? Is there anybody who thinks that persons engaging in non-cab transactions are not subject to local ordinance?
My name is Jennifer Allman, and I would think that they are still subject to local ordinances because nothing in the opinion exempts them from local government authority. But to the extent that the ordinance is valid and has been upheld by courts, I think that it should be read on its face, and that organizations should be held accountable for compliance with local ordinance.
Question. So do you feel like, I believe some of those ordinances refer back to the statute and try to describe them as cab transactions? So to the extent that they are CSO non-cab transactions, to think that the local ordinances will apply.
I think you'd have to look at each of those transactions to see what the actual transactions are. I've not yet seen any CSO non-cap transactions yet.
Okay.
Any other questions, comments, or suggestions with respect to local ordinances and non-cab CSO transactions?
No, nothing further.
Okay.
We'll make one quick comment. This may explain partially, I can correct that. May explain partially why it's quiet, but these are difficult questions to answer because they're so broad. It's kind of like saying, do the speeding laws apply to everybody? Well, yeah, but if I'm a law enforcement officer and I'm an emergency or I'm an ambulance driver, so it's very difficult to answer some of these the way there were. And that's not a criticism because it's very difficult to try to capture what you're trying to capture, and I get it. But you would have to look at each because the ordinances can be different. They can vary from municipality to municipality. So you have variances there. And in terms of what you're talking about specifically, I think it's a very fact-specific inquiry as to whether or not a particular transaction falls under an ordinance. And so to answer it broadly is very difficult. Clearly, to the extent that there are, and this is going to sound disingenuous, and I don't mean it to sound that way, I really don't, but to the extent there are ordinances that apply by their definition to transactions that meet those definitions, yes, they do apply. I don't think the AG opinion changes that. But without looking at specific fact situations and specific ordinances in play, it's very difficult to answer these broadly.
Can I ask you a specific question? For any of the clients that you represent, do you believe that any of the products that they offer that they contend don't apply or won't, the city ordinances, local ordinances will not apply to those?
Well, again, I would have to look at specific ordinances. And honestly, to be fair, my comments here were not intended to be on behalf of a particular client. They're really, as somebody, I was an administrative judge for 19 years. I've taught Texas administrative law. It's really intended to kind of look at the overall process and offer comments on my thoughts about that, really from almost more of an academic standpoint than representing a particular client. My comments, I can tell you, are not, what I've offered today are not intended to be representative of a specific client in any way. It's really just intended to offer my own interested comments in terms of these issues. So, to be honest, I really couldn't answer that question specifically because I haven't looked at any particular products and then applied them to particular ordinances for purposes of speaking today. So I'm not trying to avoid the question. I just honestly couldn't answer it in a way that it would need to be answered fairly.
Thank you. We have a comment from online. This is from Melinda Ramos. She clarifies that she's with the city of Fort Worth, and this appears to be a comment or a follow-up to a prior question or some prior discussion. She says, this is a late response, but I don't believe that a non-cab would be subject to 393 subchapter C-1. They're not specifically mentioned in that section or subchapter G, but it might be worth looking into the legislative history. Non-cabs may not have been thought of at the time of the legislation. That's her comment. Any other follow-up on question 4, or anybody have any thoughts? Feel free to contribute, even if it's not directly on point with the question at hand. Anybody else? Okay, I'm going to move on to the next question. Question 5, are persons engaged in non-cab transactions subject to federal law and the enforcement authority of federal agencies, such, for example, the Consumer Financial Protection Bureau and the Federal Trade Commission? Or I could state it in the negative. Does anybody believe that persons engaged in non-cab transactions are not subject to federal law and federal authorities?
I would say yes, they would be.
Appreciate it.
Thank you.
Sure.
It's helpful.
I would say yes, they would be. newly been birthed. It's a non-cap operator. So they might ultimately be examined by the CFPB at some point. But I guess everybody is probably trying to figure out, well, with the payments provisions or anything else coming from the existing CFPB rule process that's going on, would that apply as it's currently written to these new operators? So that would be the question. I'm assuming that CFPB has a large enough and broad enough umbrella to really examine one of these operators if they felt it was necessary.
Thank you. Appreciate it. Ann?
I think the first part of it, of course, is the question of fact, and depending on the specific law or the specific statute. But I do think that a big question that this does raise is examination. So right now, the CFPB is not engaging in any military lending act examinations. They've stated that as a policy. The Office of Consumer Credit Commissioner, for CAB, does engage in examinations for compliance with the Military Lending Act. What happens with this gray area?
Thank you. Anybody else have any questions, comments, or insights on federal law?
Warren Cheshire, City of Austin again. Actually, just taking a little bit of clarification for the last question and for this question, are you asking essentially because there is no statute, for example, that deals with a signature loan, right? So we can't just go back and say, yes, signature loans should be regulated by cities and it's a non-cap transaction. But in this case, is this question and the previous one coming from the side of thinking of it as, do we believe that the transactions and the products that are offered by non-cap entities, are they similar enough to cap products to where they should be regulated by the ordinances and state and federal laws as they currently are? Is that the question? Or is the question, there's some new product, it is a non-cap product, is it being regulated? Because in that case, I'll agree with Ann. I mean, it is a question of fact. Is there a law that regulates it? It's a yes or no question at that point. So I'm looking for a little bit of clarification of which angle is these questions coming from.
Yeah, and again, our questions are intended to provide a context for our conversation, to promote discussion, to provide us with information and insight into our policy development activities so that we can appropriately respond to the AG opinion. And it helps us to kind of provide some context. We not only do our bulletins and our rule actions, but oftentimes during the legislative session and between sessions, we'll be asked by legislators for our insight and expertise on the state of the market and the state of regulation. So it's important for us to understand kind of different angles that may come into play.
And if anyone has input along the lines of, like, if we phrase, the question in terms of are persons subject to this law, if the answer, that stakeholders feel is right is not currently, but we believe they should be, if that's the answer, we're interested in hearing about that too. So even if the questions are phrased in terms of, is this the case right now, if you think it should be the case, I think we'd be interested in hearing that feedback as well.
And it's difficult for us to answer considering some of these questions are currently being litigated in cases that we have open. But yes, it seems that some of those transactions and some of those products are substantially similar to what it's currently written in state law, and perhaps should be, in fact, looked at as the same thing and regulated the same way. Okay. Thank you again.
Thank you. All right. Anything else? Okay. I'm going to move on to the next question. Question 6 is sections 14.101 and 14.201 of the Texas Finance Code give the OCCC authority to investigate and enforce violations of Chapter 393 with respect to a credit access business. what is the proper role of the OCCC in light of this opinion? Again, we are interested in hearing any and all opinions or perspectives on this.
Golden opportunity to tell the regulators what their role is.
Mark Jetchett, City of Austin. For those who are listening. Considering that a lot of the city ordinances report back to state law, and of course the opinions of the OCCC are held in high regard in courts, and when creating ordinances and the law, I believe that the role of the OCCC in this case would be to really lead the way and try to shed as much light as possible in the gray areas that we've already discussed. I think that's also part of the reason why the room can be silent, is because as the regulator in this case of the state, we do look towards the OCCC to come out with opinions and interpretations of the law. So some of those questions, such as should certain transactions be regulated under certain sections of the state law or federal or whatever, we do look towards the OCCC to really give that opinion beforehand. And so as local municipalities, we can find where we fit in the state's regulatory structure rather than us trying to feed that up from the bottom.
We have a response online from Melinda Ramos again. She says that I believe the OCCC does still have the authority to investigate and enforce Chapter 393. Are there other comments, insights, perspectives on the proper role of the OCCC in light of the opinion? Okay, we have another online comment from Rachana Chin, who says the AG opinion seems to give three potential options: issue a bulletin, give a formal rule on the issue, or encourage the legislature to clarify the laws per the 2012 bulletin. Quote, if the legislature finds this business practice conflicts with its intent, it could consider passing additional legislation that would put further regulatory restrictions on CSOs that obtain extensions of credit for consumers.
That's it.
All right. She's quoting from our 2012 bulletin that we issued shortly after we were tasked with regulating credit access businesses on January 1st, 2012, and was also cited in the AG opinion. Other comments on the proper role of the OCCC in light of the opinion? This is your chance. Okay. Move on to the next question. Next one is Section 393.602 of the Texas Finance Code says a person may not use a device, subterfuge, or pretense to evade the application of Chapter 393, Subchapter G. Under the opinion, what would constitute a device, subterfuge, or pretense to evade the application of Chapter 393, Subchapter G? Does the statute have meaning? Courts tell us we should read the statute to give it some meaning. What meaning does it have?
Nothing further.
Okay.
Wait. This is a very important question.
Okay.
I would expect we would get some feedback on this question. More than a,
Also, a quick comment.
more than
It's not going to answer the question necessarily directly because I don't have an answer as to what would be advised. But I think the analysis, this shapes the analysis of how you decide that. It's like, and I'll use the speeding example. If I have a device that's intended to block a radar gun, and I'm going to go 55 in a 50-mile zone, and I use that device to block them from catching me, that would be something that would seem to fit within it. If I just decide to go 49 and a half, I'm just complying with the law. And so to me, an effort to just comply with the law is not a device to avoid getting caught. So to me, when I look at this, at what a device, subterfuge, or pretense is, it would be some affirmative act, not just a compliance with the law, because arguably any compliance with the law, anything that doesn't fit within that could be compliant with the law, but it's something that clearly shows an intent to hide or deceive what the transaction is. So when I read that language, a device, subterfuge, or pretense, those are words that indicate deception or an effort to directly thwart regulation or the being caught, for example. They're not just any sort of act that would get around the effect of the law, because any act that is compliance with the law is an act that gets around the effect of some adverse consequence. So I think, to me, when I look at that, if I were analyzing it as an administrative law judge, I would say, is there some effort at deception or thwarting here? And if that's the case, then I think that's what I would focus on. What would be that? I don't know. I don't know the product well enough. But in terms of my analysis, that's where I would focus when I see those sorts of words used in the statute, subterfuge, pretense, because all of those in the law indicate deception, dishonesty.
Did you, in your experience as an administrative law judge or professor, encounter like other commercial transactions that had a similar standard or involved, transactions with a kind of substance over form analysis where you look at the economic realities of the transaction, or did you encounter that before? Because we know about some of that in the consumer finance area, but you may have experienced that in other areas. I don't know.
Well, the one that comes to mind is not necessarily that. Because with TBI, and I think it may have been Michael on this case, had a situation where what is a surcharge?
Okay.
Is removing a discount the same as a surcharge? And I said, no, those are two different things. I mean, the law, you have to try to harmonize the law. And ultimately, is the effect ultimately the same? Yes, but that's not how we apply the law. I mean, you apply the law based on the language used and what are the words. And so ultimately, a surcharge is different than removal of a discount. They're two different concepts, even though the effect could be the same. And ultimately, my decision was upheld by the Department of Insurance. And to me, that's sometimes it's tricky, but you don't just look at the effect. I think you have to be tied to the language of the statute and apply it. And then leave it up to the legislature to fix any sort of ambiguity. At least that was always my approach.
Thank you. Any other comments, insights, or suggestions about this question?
Nothing further online.
All right. I'm going to move on to the next question. The next question is Section 393.303 of the Texas Finance Code says a credit services organization may not charge or receive from a consumer valuable consideration solely for referring the consumer to a retail seller who will or may extend to the consumer credit that is substantially the same as that available to the public. Under the AG opinion, what would constitute a violation of Section 393.303? Kind of a long sentence, got a lot of parts to it. You may have some thoughts if you looked at this section. Rob does.
Michael, Rob Norcross, representing the Consumer Service Alliance of Texas. Very brief comment to my good friend Robert Howden. others in here that may represent 342 lenders, and others on the line that may represent 342 lenders. In our opinion, neither a CAB nor a CSO may arrange a 342 loan. So let's put that to bed.
Thank you. Any response to Mr. Norcross or comments about this particular section of the Finance Code?
I have a question. Has this particular portion of the Finance Code ever been enforced or examined for compliance?
I can't really, I mean, in terms of enforcement, I'm familiar, I don't recall an enforcement action that this was sort of one of the pleadings, but it's certainly a section that, you know, has been here for some time, and it's something we're not, it's not a first impression issue necessarily, but I think in this context now it sort of creates a different perspective that we need to view this with.
I think it definitely establishes a very fact-intensive analysis to necessitate whether or not a particular product is compliant with it. And perhaps this AG opinion in elevating the standard elevates this as a place where compliance should be deliberately assessed.
Does it mean an installment loan is substantially the same as that available to the public?
There's a strong argument that the answer to that is yes. There's a mention of 342 loans, and they're substantially available, and they're installment loans. They're also substantially available installment loans elsewhere in the marketplace. You know, so it is a fact-specific question, but it does appear that the Attorney General's opinion elevates this as a portion of statute that should be perhaps more deliberately assessed.
Thank you.
The question that I have for this section is related to the part where it says that somebody may receive from a consumer valuable consideration solely for referring consumer to a retail seller. So the way that this is written, it almost seems as if you were to walk into a credit access business and they were to say, well, we're not going to do this, but if you go down the street and there's this other one, that's, you know, you get the loan from there. But what if it's the same credit access business and a consumer walks into their storefront that is in Austin, Texas, and the type of loan that they're looking for would not be available for them under the Austin ordinance. And then that same CAB refers them to another CAB location of the same business, Round Rock, and then take out that loan. Now they're receiving fees for that loan. Is that considered valuable consideration? Even though that one location in Austin didn't receive any kind of money, but the entity as a whole did get the loan and is receiving the fees. That's something that I'd be very curious to know what someone's opinion would be. That nobody is receiving that in Austin, like in the city, that one location, but the CAB, the business as a whole, which is what it seems the credit services organization as a whole is benefiting from simply sending someone else outside the city.
Are you guys still seeing those referrals to another municipality outside the city?
We are, yes.
We have another comment from Ms. Chen. She says that the AG opinion states whether any specific extension of credit is substantially the same as that available to the public or uses a device, subterfuge, or pretense to evade regulation Internet access business are fact questions that this office cannot decide through an Attorney General opinion. Has the agency issued any ruling, enforcement action, or opinion dealing with the interpretation of statutory language on consumer credit substantially available to the public? I think the commissioner earlier, when we were talking about this question, said that she was not aware of any enforcement actions. I've been here for 5 years. I'm not aware of any action based purely on this particular section. Matt, do you know of any?
No.
Okay. Commissioner, have you recalled any that? Okay. Oh, I'm sorry. I apologize, Mr. Chen. I'm quite sorry, Mr. Chen. Any other comments on this particular question or this issue? Carl?
Good afternoon. Carl Gallant with the Texas Consumer Finance Association. I appreciate Mr. Norcross's comments about Chapter 342 loans. My clients make regulated installment loans or signature loans. After hearing a few comments here today, I want to make it really clear. There is a statute that covers signature loans, and one of the concerns of the TCFA is confusion in the marketplace, but also confusion among regulators and confusion among local governments who may seek to pass ordinances that restrict Chapter 393 transactions that may be bleeding into other areas that are confusing now. Traditionally, or many of the local ordinances will have a reference to state law, an exemption typically for regulated lenders making loans under Chapter 342. And so I think TCFA wants to make sure that clear line remains with respect to local regulators and the Commissioner's office. So I did want to just make that very clear. There is a product out there called a signature loan. But we agree that a CSO or a CAB is probably not making that loan. If any person is seeking to make a loan that is subject to Chapter 342, that is, it's in excess of 10%, the usury laws of the state, they must be licensed and make that loan in compliance with Chapter 342. And those are the comments that we submitted to the Attorney General. That's our position today, and that's what we'll continue to push for, to ensure that level of regulatory playing field remains.
Do you have any suggestions as to how to mitigate the risk of that confusion in light of the AG opinion?
Well, it sounds like they're not going to be making a loan, so that's okay, I guess. No, I don't know. In terms of consumer disclosure, I mean, I think the same type of products can be subject to Truth in Lending Act requirements. There's going to be a clear distinction in terms of the APR, the rates, and I guess we'll have to ask some of the consumer groups whether they think there's some other form of disclosure that's required. But the bottom line is the market will probably recognize in terms of the cost of the product the distinction between the two. But perhaps there's some other type of disclosure that's required in that regard to make it clear to consumers and regulators that there are two types of products out there.
Okay. Thank you. Any other insights into this issue? Suggestions? Okay. I'm going to move on to the next question. Next question is, does the opinion's analysis raise other significant policy issues? Open-ended. Anything you want to say. Help us understand. Last chance. All right. I'm going to move on then. I think this is the last question. Should the OCCC and the Finance Commission engage in rulemaking related to any of these issues? If so, what is the statutory basis for this rulemaking?
Michael,
Rob?
sure you're going to be shocked. No, none. I think that covers those two questions. And again, I don't want to be flippant about that. Just a quick comment, and I'm going to take one for the team here. Questions 2, 3, 4, 5, 6. In my opinion, my personal opinion, doesn't represent the consensus of our group. Most people comply with the law? Yes.
Mr. Northcross, can I get you to speak up just a little bit?
Yeah, I'm sorry.
Thank you.
Most people comply with the law? Sure. They have to comply with the law. And I think, I think we've answered question 8. We've had some questions today about what we hope the law might be, and what we wish the law might be. The law is the law, and the statute's the statute. And the rules have been promulgated pursuant to the statute. And, I think the Attorney General was pretty clear on where the line is. And the other thing, just again, for my members, and not to be critical of the process, but to expect our member companies to come testify in a public stakeholders meeting to talk about proprietary information related to their products and proprietary aspects of their products in front of their competitors and in front of people who have testified in the past that it is their intent to put them out of business is something that they should not be criticized for in the future, for choosing not to do that. I understand that, there's information that people would like to obtain, but there is a place, and this forum is not that place. Now, the other thing, and my last comment, and y'all can ask questions if you like, I'll try to answer them. We heard a lot about chaos in the marketplace today. With a CAB loan, you either have a single payment loan or a multiple payment loan. And you're either getting security in the form of title to your car or security in the form of a debit authorization to your bank account. On a CSO loan, it's either multiple payment or single payment. You're limited to 180 days, and you're not getting anything. Now, unfortunately named the signature loan, that caused some confusion with the 342 guys, and that's an unfortunate name for a product for a single company, and I understand that. But, there's 3 types of loans, mostly under $500, mostly under $1,000. I don't think consumers are confused. I think 342 members are confused. Examiners are confused. Consumer advocates may be confused. Cities who are trying to enforce ordinances that we haven't been able to litigate yet are confused. But consumers aren't confused. So if we're here today to talk about chaos and confusion, maybe we ought to get all the municipalities and all stakeholders together and hash it out, but I don't think consumers are confused. And if we're going to do rules or bulletins or anything like that, shouldn't those be done for the benefit of consumers as opposed to everybody else? Particularly when there's no statutory authority. The last statutory amendment that affected this issue was in 2011. Where's the genesis of the rule or the opinion? I'm at a loss. I'm sorry. Anyway, if y'all have follow-ups,
I do. Well, first of all, in terms of the venue, I think it would be irresponsible of us to not have this type of discussion. We are very interested in information. We have information, as do other regulatory agencies. We have sessions to gather information on policy issues and developments from companies routinely, and it's generally the way the federal agencies do it, other state agencies do it. It's the way in which we have to gather information in order to make good public policy decisions. We're a public entity. We operate out transparently. Our Finance Commission does, and it's an expectation that they have that we conduct these types of meetings as well to ensure that we gain adequate input. And this is the forum that we have available to us. I wanted to kind of switch.
Well, let me interrupt just a second. I'm sorry. I don't take issue with the fact that you're having a meeting. I take issue with the fact that people would be threatened to attend and or punished if they didn't participate to a level that there was a disagreement about. So, I don't take issue with the fact that you're having a meeting.
Yeah. Well, we're looking for information, and it's helpful to have it now instead of a year from now. Second issue is this issue about the consumer. And consumers contact us with their complaints. And so we deal with consumer complaints. I'm a bit concerned about how do we deal with the situation. Matt can probably look up the citation for me. But I believe that the requirements for CSO transactions include a notice to the consumer about if you have a complaint, contact the Office of Consumer Credit Commissioner. Right?
393-201C.
201C. But if that's a non-CAD transaction, what is the consumer to do when they call us? I mean, what are we to tell them? To me, there are some conflicts that arise here that do introduce confusion, and we're looking to find a path forward. Are there boundary lines we need to try to create? How does the consumer know who to complain to? If the Attorney General is the appropriate venue for them to go to, seems like it's appropriate that we should advise them of that, or that it should perhaps be modified in the contract in some way. But those are some things we need to certainly try to understand, and I think a consumer has a right to know where their transaction falls in the statute, if indeed we're falling on one side of the cliff or the other. I think they have a right to know that. But anyway, those are some of the issues. I think there's a bit more confusion out there, or will be. We're trying to anticipate that on the part of consumers. And what's our responsibility in terms of responding to those? Michael, you have anything else?
I agree. Yeah.
Thank you.
anybody want to argue for open, transparent, fact-based decision-making? Okay. You're online.
Nothing further.
All right. Last chance.
I commend your open, transparent, and fact-based decision-making, and I know many, many other people do as well. Having an open stakeholder process is the key to good policy. It's not only the key to good policy, but it's the obligation. You are a taxpayer-funded entity, or at least funded by your members, but still a governmental entity, and it's important to have this kind of transparency. It wouldn't be right otherwise, so I commend you for that.
Thank you. Anybody else? Okay. All right. That concludes the questions. Under our notice, we're requesting written comments and suggestions by 5 p.m. on December 12th. The purpose of that deadline is to provide information to the Finance Commission at their December 13th meeting. I understand that some members of the participants in the conversation were a bit uncomfortable with that. Does anybody want to propose a different deadline? Please.
I feel like I'm in a legislature.
We're hoping to get your steps in today.
Yeah, thank you. Long drive. I don't have any problem with folks doing their best to get comments in by the 12th. Because the Finance Commission meeting is on the 13th, I would also request, if it's possible, that if comments came in like the next week, that they would still be considered.
Absolutely, yeah.
Because I know they would be, but I've gotten some questions. People are traveling, it's holidays, that kind of thing. So they just want to make sure that if they didn't, get something sloppy in by the 12th, and they got it in the next week or so, it would be, tossed.
Now, we are always open to hearing from our stakeholders about their insights and suggestions at any time.
Right, and I knew that. I just want for everybody watching to get that on the record.
Yeah, good. Thank you. Anything else from anybody, either here in the room or online? Last chance. All right. Well, I want to thank everybody here and online for your participation in this conversation. It's an ongoing one. Again, we welcome comments and suggestions at any time, but we would appreciate if you have anything to submit in writing that you do so by 5 p.m. on Thursday. That'll help us brief the Finance Commission on the AG opinion and the perspectives, divergent perspectives of our various stakeholders. So thank you again for coming.
Thank you.